Kiati. I'm head of Joshi Advocates. Thank you very much for joining us in this video on statelessness. In the next 5 minutes, we will run through 1, what is statelessness? 2, what documents you need to make a successful application. 3, if the application were to be successful, what the applicant would get from the Home Office, as in a residence, a leave to remain, how long for. And finally, where a child is applying for British nationality as a stateless person, what are the requirements? So let's look at that. Now, first, statelessness is when a person is saying, I am not a national of any country, or I'm not recognized as a national of the country of my birth. Now, statelessness application, when made, would require documentary evidence for the applicant to prove that he or she is stateless. So 1, they should not have a passport of that country. 2, they would need to support that they have carried out all reasonable steps to obtain identification document from that embassy, consulate, high commission. Now, there is case law, and this is the practical side of the application. Say worst case scenario, okay, the applicant makes application and then the Home Office is looking at it, and then the Home Office, if were to call the High Commission or embassy or the consulate of that relevant country and say, we've got this application, could you verify this? And if they say, oh yes, this person is registered, birth certificate and things, but they cannot get the passport because XYZ document is missing, that does not make the person stateless. However, the Home Office would consider what documentary evidence is missing and whether it is in your reasonable power to obtain it. So if you know people in that country where you were born and you're saying I'm a national of that country, can you get those people to send you your birth certificate, for example? So all reasonable steps must be taken before the application is made in order to make a strong application with documentary evidence. Now, imagine you are saying that I am stateless, but you've never made an application to the Home Office. Worst case scenario, say you are detained, and then you say to the Home Office, I am stateless. Home Office will then call embassy or the High Commission or consulate of the country where they think you are from and ask, can I get a travel document for this person? Because they're saying they're stateless and we want to just confirm if we can remove this person based on the travel document issued by that embassy. And if the embassy says, yes, we'll give you a travel document, then practically you are not stateless, because that embassy or consulate of the country which you are saying you are not a national of is going to issue a travel document and facilitate removal. So be very careful when you are saying you are stateless, because the burden is on you to prove with documentary evidence that you are stateless. Right. Now, say that you have given all the documentary evidence that you are not a national of this country, you've done everything you can, and still there is nothing, you are stuck in a limbo. You can't live in the UK lawfully because you don't have an ID document, and you can't get one. And as a result, Home Office can never remove you to that country in which they are saying you're a national of. So, application successful, Home Office will grant you 5 years of residence in the UK as a stateless person. Now, the interesting bit, say it's a child who is saying he or she is stateless and is asking the Home Office for British nationality as a stateless child. There is development in this, and it's a positive development. The Home Office is now saying, based on case law, that even if, say, a child can register the birth in the High Commission, consulate or embassy, but still is not considered national of that country, because, for example, say the child is registered its birth in that High Commission, consulate or embassy, but the embassy is saying, no, there are other requirements to be met. For example, the parents need to be married at the time of birth, or one parent needs to be of one nationality, and so on. There are other requirements. The Home Office is now compelled by case law to accept that the child is stateless. Again, documentary evidence must be provided, but the flexibility is that even if the child's birth can be registered, there's still possibility of the child being stateless. provided the A, child is born in the UK, and B, child has lived in the UK for the first 5 years. Now, thank you so much for joining. I hope this has been helpful. For any further questions, as always, contact me, details below, subscribe, and I'll see you very soon. Thank you so much for joining. Take care.